Hello, everyone, and welcome to our webinar, Legal Update. My name is Miranda Ward, and I'm the Client Relations Director for Adams Stirling. We are thrilled to see so many of you today. We have a lot of information to cover, so we're going to get started. Before we begin, this meeting is being recorded. If you require closed captioning, please request it at the bottom of the screen. This video will be available on our YouTube channel after the webinar is processed. We will be taking questions via the Q&A function to be discussed at the end of the program. If we do not get to your questions, please check the newsletter. Some questions may be answered as the presentation progresses. Too specific of questions will not be addressed. This program has been approved for CAM, ICB, CMCA continuing education. At the end of the program, a survey will launch asking you if you would like a certificate for attending today's event. Please make sure to stay to the end to get that certificate. Now on to the presentation. Please welcome our own Rob Ward and Jamie Hendrick.
Hello, everyone. This is Rob, and it's nice to see so many of you are joining us today for our little lunch presentation. Hopefully you have your bag lunch with you and can follow along with us. So I'm the partner in charge of Orange County in this law firm, and Jamie, who is with me, is the partner in charge of San Diego, Inland Empire, probably a whole bunch of other places too. Right, Jamie? But the reason we're doing this today for you guys is we're both serving on the LSE committee in San Diego. We have for several years now. So it would make sense that we would want to deliver the news on this year's batch of legislation for you. You know, over the past few years, we've had some seriously complex and involved bills to deal with. You know, they affected election law, electronic voting, as you may recall, which we're still seeing, trying to develop with our communities, a lot of housing and ADU type bills, you name it. But this year, really, the bills were not all that complex, thankfully. So we get a bit of a break on interpreting some of this complex language and how these are going to really affect you guys, with the possible exception of our friend AB 130, which we are going to touch on today a little bit later, but not in too much detail. We did a whole webinar on AB 130. You can find it on our website. Please check it out. But we will talk about it a little bit today as well. So there were some bills that ended up dying in committee this year, like the manager licensing bill you might have heard of. There was one about residential heat pumps that ended up dying in committee. And you can see the score on all of those on our Davis-Stirling website under new laws, along with the ones that we're going to talk to you about today. Please note that this is not intended to serve as legal advice for you, and you should always consult with your own attorneys about all of these bills and cases. And of course, we'll be available, as Miranda mentioned, at the end for questions. So with that, let's go ahead and get into the bills that we think are relevant to your communities this year in 2025. And we're going to start with Jamie talking about one of the hot ones, actually, SB 770. Go ahead and take it away.
Okay, so SB 770 is the electric vehicle charging station statute. That's how I like to refer to it. They made a change this year. The main change is that it amends Civil Code Section 4745, and it removes the requirement that owners of EV charging stations provide a certificate of insurance that adds associations as additionally insured under the homeowner's liability policy. So if you'll recall, most EV charging station policies as of now have language that says if a homeowner wants to put an EV charger in, they have to include the association as additionally insured on their personal liability policy. Well, that's out the window now. That is no more as far as the code section is concerned. What is the result of this? The result of this is that it could shift the burden of liability from the owner of the EV charger to the association, because now the association's insurance is going to have to cover situations where there might be damage caused by an EV charging station. So if there's a fire, there's a malfunction, there's property damage that results, most likely now the association's master insurance policy is going to have to cover that damage. So it's really not a great scenario for HOAs. And then you have to consider, okay, what else could happen? Well, as we all know, insurance premiums are increasing just as a general rule. So most likely the insurance policy is going to increase as well, because now we don't have this additional insured requirement anymore. So that's the good news on that. I'm going to, there really isn't any other change, any significant changes to the bill. That's it, but I think that's enough. So Rob, I'm going to hand it over to you to talk about SB 410.
All right, let's talk a little bit about SB 410. And if you haven't heard about this one, it involves the disclosures that are made to prospective purchasers on those SB 326 reports, the exterior elevated element inspection reports that everybody has been doing over the last 5 years because they were required to. So of course, I know that all of you have gotten your SB 326 reports done for your communities that have these exterior elements. And if you haven't, please get on that. It was due this year on January 1st. And we're going to talk a little bit about what this bill does, which really, it amends Civil Code sections, let's talk about all of them: 4525, 4528, 5200, 5210. 5551. Now that seems really incredibly complex, but it's not. It's going to require HOAs to provide the latest balcony and exterior elevated elements inspection reports. So those 326 reports that we're talking about to prospective buyers in their sales disclosure documents. So a few words about 326. I mean, you all know what that is. It's the balcony bill. It came around because the legislature was aiming to increase transparency and safety for buyers and residents after the fatal Berkeley balcony collapse. So back in 2010, that bill 326 became law, and it gave you 5 years to do your inspections. From that point forward, you would need to do inspections every 9 years. And you can hire certain engineers, and we actually had a bill last year that allowed for civil engineers to get involved in that because we saw that there was a shortage of those engineers doing these inspections. So this bill, along those lines, was sort of in comport with the California Association of Real Estate. They supported this bill. They wanted to see the transparency. The people that opposed this bill were really the drafting engineers of those reports. They wanted to oppose it unless their entire report was disclosed. They did not want to get into a situation where excerpts were being produced to prospective purchasers that didn't tell the whole story of what they did with their inspections. So, there was the possibility that people could cherry pick and present only the good news and not the bad news, so that the architects and engineers doing these inspections could be called into question or possibly even sued. So there were amendments to this bill after the opposition, and CAI originally opposed it, but after the amendments were made, CAI went ahead and supported this bill, and of course it was signed into law. So you want to keep in mind 3 important things. The first thing I'm going to mention is that it's in red here on your PowerPoint. You need, or Civil Code section 4528, the billing disclosures form will need to be updated to reflect the changes to the Civil Code noticed here. I think that we have that form on our website. I'm not sure. Jamie, do you know if we actually?
I'm not sure, but
not. I think we're going to try to get it on. We discussed that earlier, so hopefully that's there. But that billing disclosures form is going to need to be updated. The second thing to keep in mind is that members are able to inspect these reports. These are going to become part of the association's formal business records. So when you get those requests, and we get them all the time from members who are demanding to see certain financials and things, those records are going to become a part of those that should be disclosed. The third thing you want to know is that these reports, and this is going to be interesting, these reports must be maintained for 2 of those inspection cycles that I mentioned earlier. Remember how long those were? Those inspection cycles were 9 years. So every 9 years, these inspections need to be done. And what this bill requires is that those reports have to be maintained by the association, either through the management company or through the board, for 2 inspection cycles. So if my math doesn't fail me, that's 18 years. So it's kind of remarkable that the legislature is requiring these old reports to be kept around, and in year 17, you're going to have to produce these reports that show what happened, let's say it was 17 years ago today. What is that, 2000 something, 8? I don't know. It seems a little bit ridiculous, but let's hope that managers and boards, and this is the takeaway from 410 that I'm going to give you until we go to the next slide, is that managers and boards are going to need to preserve those reports and keep them. And that shouldn't be a problem with digital technology now. You should be able to keep those files around, but keep in mind that they are required to be maintained for those 2 inspection cycles. So let's go to the next slide. And we're going to talk a little bit about what needs to be on the first page of the EEE report that you're going to want to discuss with the engineer or the architect that does your report. This bill clarifies that 5551 applies, first of all, to buildings containing 3 or more attached multifamily dwelling units. So there was a kind of a question before as to which buildings needed to comply with SB 326, and were things like duplexes or a collection of duplexes. Did they need to be in compliance with this bill? Well, this bill is clarifying that, so that's actually a good thing. So you know that 5551 is only going to apply now to buildings containing 3 or more attached multifamily dwelling units. So going forward, keep that in mind. And we're also going to make sure that there is certain information on the reports. And it's listed here on your PowerPoint. You can see that the date of the inspection will need to be on the first page. The total number of units, with the exterior elevated elements will need to be on that front page. So it's sort of a list of data that you're going to need to have on the front page. The total number of EEEs in the project, the total number of EEEs that were inspected, the total number of inspected EEEs that pose a safety threat, and the number of affected units, not infected. We don't have an infection here, sorry. And finally, the inspector certification. All of that information is going to need to be on the front page. So if you've already gotten your reports done, you don't need to worry about that now, but as of January 1st, going forward, when you get these inspections done, make sure that all of that information is on the first page of the report, and have that discussion with the engineer in case they are not aware of SB 410's requirements. Now, Jamie, I hear that you have a few issues with this.
I do. Aside from the fact they're going to have to use really small font on the first page to fit all of that in, I personally do not like this bill. And let me tell you why I do not like this bill. I don't like it because I've already seen how things can go sideways. So let's run through the scenario. We've had some clients already who have produced the SB 326 inspection reports at the behest or request of a homeowner trying to sell their condo. Board and management said, okay, fine, this homeowner is trying to sell the unit. They're saying the lender needs this information to underwrite the loan for the buyer. We really need the report. And the homeowner is, emailing management about 5 times a day, insisting they're entitled to a copy of the report, which, by the way, in my opinion, they're not under current law. They will be come January 1. But, the report gets turned over. Okay, so the report gets turned over to the seller. The seller provides it to the buyer provides it to their lender, Fannie Mae, Freddie Mac in particular. And Fannie Mae and Freddie Mac look at the report and they say, oh my gosh, this report says there's a tiny little crack in a balcony about 5 buildings over from the unit that's being sold. We have a problem with that. We have concerns. We have issues. We're not going to fund this loan because we don't like what the report says. So then escrow falls through the buyer backs out because the buyer can't get money to buy the unit. And guess what? The homeowner trying to sell turns around and blames the association for the failure of escrow to close. So I have an issue with this bill because I don't think it was carefully thought out. I think there are going to be a lot of escrows that fail as a result of HOAs having to be required to turn this report over. So that's my 2 cents.
Yeah, that is a concern, and I agree with you, Jamie, that this is going to have possibly some effects on escrow closures and things. You know, I wanted to mention also that I will be attending the CLAC annual planning conference tomorrow, and we are going to have a lively discussion about things like AB 130, but I'm also going to bring up the concerns that Jamie has as well with SB 410 and see if there's something that can be done about getting a task force to look at this and consider the effect that this may have on escrows. So hopefully that's going to bear some fruit next year. We do this every year. We try to address the concerns that we had with bills or bad bills that were passed in Sacramento. And we all know that bad bills get passed in Sacramento. So
Yes.
it will be a lively discussion tomorrow. And that's going to be one of the things I bring up.
All right. Well, should we move on to the next bill?
I think so. Let's go ahead, and I'm going to talk to you guys a little bit about a bill called SB 547. We can go to the next slide. And this is a real simple one. I'm not going to spend a whole lot of time on it. It's about insurance, and existing law provides a 1-year moratorium on insurance cancellations already. But what this bill does is it prohibits an insurer from canceling or refusing to renew a commercial property insurance policy, which we'll talk about what that means in a minute. But it's for 1 year from the declaration of a state of emergency. So this bill doesn't even really have any effect unless we get into that situation like we had last year in Los Angeles with the wildfires. And that's sort of what spurred this bill from being discussed and passed. It does provide the 1-year moratorium, assuming the commercial property insurance or the commercial property in question is located within the perimeter of a wildfire or in an adjacent zip code. So not just in the wildfire zone, but an adjacent zip code will also be afforded this protection. And so that's a good thing. I mean, it extends the conditions and exceptions of the 1-year moratorium to include certain commercial insurance policies. It's the same as in existing law. The policies that are not included in this are things like inland marine, transportation, commercial automobile insurance, things that don't really apply to HOA, so we don't really need to worry about an exception here. There's also another exception for when a policy has an annual premium of $25,000 or more, which we know a lot of our HOA policies are that much at this point, or even much more. But it also includes where the insured employees or employs at least 25 employees on average during the prior 12 months. So most HOAs do not employ more than 25 people. And so that exception is probably not going to apply to you either. What it does, though, is it also clarifies that this protection is primarily going to be for commercial, residential, or habitational purpose policies, homeowner association policies. And this is what is funny, because I'm kind of reading this from the bill itself, and they identify different entities that are kind of the same entity. They don't really understand yet what HOAs are. And so we continue to try to educate them up there. But the policies ensuring homeowner associations, condominium associations, long-term rental hotels or motels, apartment complexes, condominium complexes. So again, we're repeating ourselves a little bit. Multifamily dwellings with greater than 5 units, which can be a PUD, student housing, and senior living facilities. So all of those entities that have the type of insurance or commercial insurance that HOAs usually have are going to be protected by this moratorium. And so it's good news, really. And it's not going to come into play unless, again, we have another wildfire situation that causes devastation, and insurance companies start hightailing it out of California again and try to cancel on you. If that should happen, and it's probably, it could be within the year of a declaration of emergency by the governor, let your counsel know so that they can question that and challenge it. And that's really all this bill says. Anything to add, Jamie?
Nope, not on that one.
Okay, well, great. Let's just keep rolling then, and let's talk about SB 625, and that's over to you.
Okay, so this is another bill that I think was the result of the LA fires primarily. So for context, if you want to think about this bill as a situation where you had with the LA fires, you have single family detached homes that were destroyed by a disaster. In that case, it was a fire. What this does is it adds Civil Code Section 4752, so it's a new code section. And the code section voids governing document provisions that prohibit or effectively prohibit. So either way, they either outright prohibit or effectively prohibit a substantially similar reconstruction of a residential structure that is destroyed or damaged in a disaster. So what is a disaster? How do they define it? The code defines disaster as a state of disaster or emergency declared by the federal government, a state of emergency proclaimed by the governor pursuant to Section 8625 of the Government Code, or a local emergency proclaimed by a local governing body or official pursuant to Section 8630 of the Government Code. So if you meet the definition of disaster, that's when this bill applies. The other thing that's really important to know is that an owner who prevails in enforcing this statute is entitled to reasonable attorney's fees. So, you know, if an owner decides they have to sue because the statute's being violated, they could potentially get their fees. The other disaster, besides disaster, the other thing I wanted to let you know the definition of is substantially similar reconstruction of a residential structure. Well, what does that mean? That means a proposal that rebuilds a residential structure on a separate interest located in a common interest development that complies with the local building code. And then I'm paraphrasing because it's a very long definition. So it has to comply with local building code and the square footage, setback, and height restrictions listed in this statute. So there are a lot of details in this statute, and I don't want to get too in the weeds about definitions and things like that, but I think you really need to make sure if you're in a situation like this where there is a disaster that destroyed homes, you're aware of the timelines that are contained in this code section and the architectural procedures. And I'm going to talk about those next. So the same bill adds another section, which is 4766 of the Civil Code. And that adds this extra layer of architectural procedures that need to be followed. So when the association is reviewing any application for reconstruction of a residential structure that was destroyed or damaged by a disaster, the body, that's what the statute says, the body has to review the architectural application. What's the body? The body is defined as the association, the architectural review committee, or a similar body. So it's very helpful when they use the term body to define the term body. That's, yeah. So Rob, a little note for your planning meeting, maybe we could clean that up a bit.
So we're going to talk about bodies tomorrow. All right.
Yeah, please
Great.
talk about bodies, because the body is, you know, I think it's very confusing. Anyway, here's one of the key kickers of this statute that you all need to know about if you're faced with this situation. What the code says is the body okay, must determine whether the application is complete or incomplete and provide written notice to the applicant within, actually, no later than 30 days after receipt of the application. Why is this important? Because if you don't respond to the applicant within that time frame, it's considered complete. The application is considered complete. So if you don't meet that time frame, statute says that application is considered complete, which in all reality, it may not be. So make sure that you look at that, you comply with the timeline, and they don't get a complete application by default because you failed to respond to the applicant. The other thing to know is that there are procedures if the application is incomplete. There are procedures for resubmission of the application. There are procedures for appeal of the application. So those are all in this statute. There are timelines and deadlines that have to be met for each of these procedures. So make sure you look at it. Make sure you talk to association counsel if you are faced with a situation like this. The only other thing I'll say is that this bill also amends some sections of the government code in order to streamline the redevelopment process. And that's for developers. So if a developer comes in, let's say several buildings in an HOA were burned down, and a developer wants to come in and redevelop the community, there are changes now to the government code section that make it easier and quicker for developers to apply and receive approval from the local authority to build the community back. That's it for me for this one.
Yeah, so this is another one that's, you're not going to run into very often because it's really only in play when there's a reconstruction effort being made after a disaster.
Right.
And so, you can see what the legislature's focus was this year after the LA wildfires. They really wanted to make sure people were going to be protected and that they had the ability to rebuild and not allow, the red tape, so to speak, to get in the way of that process. So that's why you've got 625, and hopefully nobody will have to go back and review this, because that would mean that something awful has happened.
Right.
But assuming that has happened, be aware of it, and of course consult with counsel if you have any questions about these steps. All right. So everybody's still awake, right?
Yeah. No sleeping. No sleeping, anybody.
Come on. Have another bite of lunch. It's all right. We're getting through this.
We're halfway there.
Why don't we go over to the next one, which is going to be mine. And this is AB 1154. And this is something that you may run into more often than a reconstruction effort, because this has to do with junior accessory dwelling units, JADUs. So everybody knows what a JADU is, right? Because we had several bills over the last few years that involved construction of ADUs and JADUs. This law is ever developing and changing, as you know, because the legislature sees these, what we call granny flats or ADUs, as a means to alleviate the housing crisis that continues to confront Californians up and down our great state. Of course, we've also now seen the effect that unrestricted construction of these improvements have on the resources available to our community associations. Parking problems, electrical use, the impact on amenities, etc. We've seen that ad nauseum, and we continue to deal with those problems. But here, the legislature is trying to help us out a little bit by, first of all, amending Government Code 66333. And that's the code that grants the local agencies the authority to create ADUs or JADUs in single-family zones through the passing of an ordinance. So the main thing you want to note about this, and again, it's very simple, is that this bill requires owner occupancy of a single-family home with a JADU only if the JADU is going to share bathroom facilities in the existing structure. So there's specific requirements, including limiting JADUs to one per lot, But the owner occupancy requirement does not apply if a government agency, a land trust, or housing organization is the owner. And that's not usually the case, of course, but in cases where you've got a single family home, a JADU was constructed, whether it be in the garage or wherever, and you're going to be sharing those plumbing and bathroom facilities. They're going to require that owners occupy that superstructure. The other thing that this bill does is it allows or requires that rentals of that JADU be longer than 30 days. So no Airbnbs in the JADUs alone. You can't do that. And that's really it. You know, there's nothing too huge or complicated about this bill. Just remember that owners who have their JADUs approved and propose to be sharing bathroom facilities need to occupy that unit. So that's something that management or the board is going to have to keep track of, or they're in violation of the government code. So consider adding that to your ADU or JADU policy in the future. And that's really all that one is. Jamie, do you have anything to add on that one?
No, I am happy about the 30-day limitation. I think that's good.
That's a good thing. I agree.
Yeah.
And so that's really the long and short of that one, AB 1154. So let's go on to the next one, and I'm almost afraid to.
Our very favorite.
You guys all know what it is. And we're going to talk a little bit about our friend AB 130. Thrilling stuff we've had so far. I agree, but here's the big mama. Let's talk about something that's going to get under everyone's craw and already has. I've actually helped draft the CAI bill brief for San Diego, and I refer to this bill as the scourge of 2025. So you'll see that in print soon. It's effective as June 30th this year, so we've had it as our law for 3 or 4 months now. And you may recall that this was the one that was kind of slipped under the door at the last minute with
sneaky.
Yeah, it was slipped under the rug, part of the larger budget bill that was passed. There was no discussion or debate about it. It was in the form of a bill prior to that, SB 877, I believe it was, that ended up dying because the author was able to get his language into the budget bill. Very shady. We didn't appreciate that happening because there are a lot of problems with this bill, as you all know. And again, we've done a webinar on this. Lori and I did one. It's on our website if you want to check it out. There are tons of opinions about it out there, so you'll be able to find it. But we're gonna gloss over it a little bit today and talk a little bit about AB 130. And again, at that AP conference tomorrow, this is going to be a huge topic of interest, and I expect to see efforts at the very least to try and make some changes to this, amend it, introduce some cleanup legislation, whatever needs to be done, because it's a problem. This is the bill that amends Civil Code sections 5850 and 5855 about enforcement. Associations are not able to impose a monetary policy now, a fine of more than $100 per violation. What does that mean? Well, with certain exceptions, which I'll discuss with you in a moment. If the association's fine schedule contains a lesser amount than $100, then you're okay. The lesser amount must be used. And so if you've got 50 in there, 75, whatever it is, then continue to use that if you like. But you can't go over $100 unless an exception applies. And in most cases, if you haven't already, you should probably consult with your attorney on updating and revising your enforcement and fine policies to be in compliance with this monstrosity. Now, can you impose higher monetary penalties? Yes, in certain situations. Excuse me, I'm getting tongue-tied here. I get worked up when I talk about this bill, unfortunately. So these higher penalties can be imposed, but only if the violation may result in an adverse health or safety impact on the common area property or another association member's property. What that means, we're still kind of figuring out. In any event, prior to imposing that higher penalty, the board has to make a written finding specifying what that adverse health or safety impact is in an open board meeting. Associations will still need to have the fine schedules for these types of violations. So amending and revising your fine policies are crucial if you want to allow that to happen. They should be incorporated into your policies. Let's talk about the big picture here. There's other aspects of this. You can impose late fees or interest on these fines, and you've all probably heard these discussions already about how this is going to work. It really depends on how your community is going to define, these loaded legal terms, like what a violation is, what curing means, what health and safety are, what a financial commitment is. Let's go to the next slide. You have to give an owner the opportunity to cure the violation, as you know. Your fining process is probably going to change, but there are many processes that are not going to change. So in most cases, your community is going to start with things like a standard courtesy notice that you'll send out that identifies what the violation is, and followed by a month or so later with another notice calling someone to a fine hearing. And you can still send those courtesy notices and attempt to get compliance in a friendly way. This is what we advocate in our firm all the time. What we're trying to do is promote compliance. The purpose behind fining and enforcement policies is not to punish people. It's to promote the compliance so that everybody's following the rules in a friendly way. And so now, though, instead of like a third notice and escalating fines, the legislature probably is going to want you to proceed directly to IDR or ADR, file a TRO, a restraining order, or even a lawsuit, much sooner than you would normally. You can impose discipline if the violation is cured, and they're given the opportunity to do that. And or if they have made what we call a financial commitment to cure. So again, we don't know what financial commitment means. It could mean that they've secured an invoice or retained an expert to cure a violation. It could mean that they have spent money on materials, something like that. We're not quite sure yet. Again, this is all going to be talked about tomorrow. This is all probably going to be litigated in the very near future as people question what those terms mean. If you do reach an agreement, then there has to be a written resolution. I think we discussed that already. And if there's no agreement, then what the legislature is probably going to want you to do is go to IDR. And if not resolved in that capacity, then we're probably facing a lawsuit. It has the chance to keep us attorney folks pretty busy, as you might imagine. If the members just don't want to cure and don't want to comply with the violation and the request for compliance, especially on higher value violations. If I have one community now, I'll just give you an example that the association is fighting with an owner that started his own fishing business illegally in a lake community. And with no authority, it's a violation. It's causing nuisance. There are significant issues with this fishing business. But the owners are making money hand over fist. And so you can imagine that a $100 fine does nothing to cure that. Literally has no value. It's just the cost of doing business for them. And so these are the types of problems that we're seeing with AB 130. These are the things that we're going to discuss tomorrow about how we correct them. I've actually heard a story about one owner who was sending an envelope with a $100 bill every month to the manager to say, here you go. And I'm going to keep doing what I'm doing. It does not matter to them. So, if you do have lesser fine amounts, that's fine. But the escalation now is a problem. And so you can't charge late fees. You can't charge interest. What can you do? There isn't a whole lot, really, absent filing a lawsuit. And so I hope that, this doesn't become overwhelming for communities. It doesn't cost communities a lot of extra money having lawyers file lawsuits and TROs, but I fear that is going to be the result here. And I think everybody agrees with me on that. So this is what we're going to talk about, and this is what we're going to be dealing with until things change in the courts and up in Sacramento. One thing I want to make sure you remember is that there are other ways to enforce your rules and not just fining. Don't forget that if you have amenities, if you have a clubhouse, if you have things like a pool or a gym access, you can suspend those. That's part of the enforcement process, and if people aren't going to comply, then they need to feel it somehow. And of course, towing policies are still viable. You can tow folks who don't follow the parking rules if you have a towing policy. You know, the situation has come up, or the example of somebody who parks illegally one night, and they're given the opportunity to cure. Well, they cure it by leaving the space and parking somewhere else illegally the next night. So how do you overcome that? It's definitely a problem. This bill is riddled with issues, and rest assured that we're not going to let it go. We're going to keep on it and see what we can do to amend this. But that's sort of my brief overview of AB 130. I don't know, Jamie, if you have anything to add to that.
I don't. I mean, I just think that the court system's going to get clogged with these cases. And as we've experienced, the judges really don't like these cases. So I just think that it's going to put an unnecessary burden on the judges and our court system that's already overloaded, and cost the association a ton of money to get these violations remedied. And it really doesn't make any sense to me. It really doesn't. I have a headache already just thinking about it. So
well, there's a lot of disagreement in the community about how this is going to play out, but I think everybody agrees that it's a bad bill.
Yep.
And so more to come on this.
Yeah.
Keep your eyes peeled for any changes that we can possibly muster through CLAC and through other organizations that are fighting this. All right. That's really all of the bills that we wanted to talk about today. We're going to talk to you about 3 cases now, and even those aren't all that interesting, really. But we're gonna give you the ones that are published because you need to know about them. There are several unpublished cases that are pretty interesting, actually, that are more interesting, but because they're unpublished, attorneys can't rely on them as authority in court. They're just persuasive authorities. So we're going to tell you about 3 cases now. I'm going to start with the first one, which is called 11-1640 Woodbridge versus Farmers Insurance Exchange. You guys all know about Farmers. They're one of the big insurers who hightailed it out of California recently. And probably this case may be partially why, I don't know. But I'm going to tell you a little bit about this case. This goes back to 2021. And the association, I'm not going to say the whole name because it's a mouthful, but the association experienced some pretty significant interior damage to their building because of a couple of rainstorms back in 2021. You remember back in 2021, there was a lot of rain, there was a lot of water damage resulting from that. It caused a lot of strife and it caused a lot of insurance claims, and this was one of them. So the HOA filed a claim under their condominium policy with Farmers. And Farmers, of course, denied the claim on the grounds that the damage was resulting from a non-accidental faulty workmanship exclusion. And one other as well, the water intrusion exclusion. And I'm really not going to get into the weeds on insurance law on this, but I'm just going to tell you a little bit about the facts and what happened. What happened was the company was hired to do a re-roof at this building. The roofer was, they called themselves the local roofer, but the guy was named Bardalis. And he was going to tear down the community's roof. Pretty standard scope of work. He's going to remove the tiles. He's going to remove the underlayment. He's going to inspect and remove dry rot, framing members, things that you've probably seen happen in your own communities when a roof job is done. But again, back in 2021, there was a lot of rain, and this was being done in September, October. So there was a lot of rain going on back then. And after he had removed 80% of the roofs and the roof membranes, it started to rain on October 4th. And the exposed insulation and plywood was damaged as a result of that rain. So he had to go back, Bardalis, and remove and replace the damaged insulation and plywood as well. And during this process, he covered that with a tarp to try and protect it. Well, guess what happened? Another rain event happened. Yeah, we had a lot of rain back then, and it blew off some of those tarps and caused even more damage. Okay, well, claim was made to farmers. Farmers blamed Mr. Bob Dawes, the roofer, for falling below the standard of care. And what they cited was their faulty workmanship exclusion, among other things, to deny the claim. So the Superior Court in LA County granted them summary judgment, granted farmer summary judgment, and agreed with them. They concluded the policy did not cover the HOA's losses due to the water damage exclusion and also the faulty workmanship exclusion. I'm not going to read you what these exclusions are because reading insurance policies is surely going to put you to sleep, and I do not want that to happen. So those were the exclusions they relied on. The trial court agreed with them. Case went on appeal, and the second appellate district reviewed the case, reversed that summary judgment. So what the court found was that the condo policy was what we call an all risks policy. And it covers all damage unless specifically excluded. And that's important. The court determined there were tribal issues of fact as to whether those exclusions cited by farmers, the water damage exclusion, the faulty workmanship exclusion, precluded the coverage. Farmers was arguing that the condo building didn't have a roof for a while, for the time it was exposed. So it didn't have to insure what was being taken apart by the contractor, and it was all the contractor's fault. However, the court noted that the property did actually have a roof. It was just being corrected, and that the damage could have been caused by both the rain and the possible faulty workmanship of the contractor. So what the court said was that farmers didn't establish that the damage was solely caused by faulty workmanship. It could have been any number of things. And because it's an all-risk policy, the HOA's losses might be covered under the policy. So they reversed that summary judgment and remanded the case, allowing the HOA to pursue its claims, which is a good thing. The HOA was actually awarded its appellate costs on this, and what the lesson here really is that it's, first of all, it's wise to ensure your vendors are protecting the property adequately from the elements during the winter months. If they're going to be working on the roof and leave a hole, make sure it's protected, or you're going to find yourself battling your insurance company for coverage. But also keep in mind that you can't always rely on what an insurance company says is true. They don't necessarily make the right decisions in your best interests. They're going to make what's in the best interest of their shareholders and deny coverage where they can. This is a common problem with insurance companies. And so always consult with an attorney if you find that you're in one of these situations where it seems suspect that they're denying you. There are attorneys out there that will go to bat for you, and coverage attorneys and anybody else who can file a bad faith claim if you feel that that insurance company is not holding up their end of the bargain. So that's really all you can take from this. It was an insurance battle. The opinion is really long. It's like 25 pages long. There's a lot of case law that they go through to get to their decision, but I think it was the right one. And so they found coverage, and that's the bottom line. If you have an all risks policy, it's not so simple that they can simply rely on one or two exclusions. It may be the case that there is coverage. So that's the long and short of that case. Insurance law is just fascinating, and I encourage all of you to read insurance law books if you want to fall asleep at night. But fun case. Anyway, we're going to go to the next one, and that's Jamie.
All right, so I'm calling this one the Ross Morgan case because I'm not even going to attempt to pronounce plaintiff's name. I don't want to butcher the name of these folks, so we're going to call it the Ross Morgan case. So in this case, the association imposed fines over $106,000, those days are over, against a tenant for violations of the CC&Rs. Yep, you heard me right, a tenant, not an owner, a tenant. So I don't really know how that works exactly. And unfortunately, the court did not analyze that aspect of the case. I wish they had. But what this case was about and what it focused on was violations or supposed violations of the Federal Debt Collection Practices Act. The tenant sued the association's management company, Ross Morgan, for trying to collect the fines of $106,000, saying that the management company was violating the FDCPA. The court said, well, fines are not consensual transactions, and that means the FDCPA is limited to debts that arise from consensual transactions, and fines are not debts under the FDCPA. So the management company prevailed in this action. It sounds to me like the plaintiffs may have sued under incorrect law, according to the court. The court said you can't pursue an FDCPA violation for something that is not a debt under the act. So just to distinguish here for FDCPA purposes, the court said homeowners association assessments are considered a debt under the FDCPA and are a consensual transaction because when you own property in an HOA, you agree ahead of time to pay assessments. The same is not the case for fines. They are not consensual. You don't agree when you take title to property in an HOA to pay fines. So that is the difference that the court made, and the management company prevailed. I still would like to know about the tenant issue, but I guess we'll never know. So that's it on that one.
Good times.
Yeah.
We've got one more for you, and we're running short on time, so I'm going to speed through it so I can give you guys a few questions. But this is the Ridley versus Rancho Palma Grande HOA case. This is one that's already been cited to me by counsel in a water damage case. So interesting stuff. It's another water intrusion case. They seem to like when I do the water intrusion cases. I don't know why. That's okay. This is about when an HOA ignores its duties under its covenants and restrictions, what can happen? The consequences can be devastating. So in this case, a Santa Clara couple got a $1.8 million judgment after their condo was rendered uninhabitable due to water intrusion, mold. There was a sinkhole. And it was all caused by an abandoned well that was found underneath the property in the crawl space owned by the association. Court of Appeal upheld the judgment, and what they found was a little shocking, and really it goes right to the lesson that I'm going to tell you about today, and that's that the HOA's delay, their deception, their failure to act or investigate breach the duties under the CC&R. It's really bad. What went wrong was that tenants of the owners of this condo at this place in Santa Clara County found persistent water pooling in their crawl space underneath the unit. It was causing damage, severe water damage, mold, like I said, a sinkhole below their living room floor. And what happened was investigations revealed that the unit was on top of this 400-foot plus well. It was revealed that the HOA board had access to maps and records from the Santa Clara Valley Water District showing the possible presence of the well, but they failed to disclose that information to any contractors or city officials. They effectively ignored the problem, trying to slough it off on a high water table. And at trial, the HOA's president even admitted to knowingly providing false information, including denying the presence of the mold itself, even though it was clearly present, and asserting that the unit did remain habitable. It really was not. So despite knowing about the problem, because the HOA delayed in a meaningful remediation for more than 19 months, that's a long time, you guys, it caused extensive damage, it rendered the unit uninhabitable, and the HOA was found liable for that. It really underscores the fact that HOAs have a non-delegable duty to investigate and repair conditions in common areas that affect homeowners' units. That crawl space was HOA property. They had an obligation to investigate it. And even when they did, they didn't listen to their contractors. They didn't listen to the experts. There was inaction, there was misrepresentation, there was concealment. It was really bad. And that's why the HOA took it in the chops and got that big judgment against them. So prompt action is really critical when you hear about things like water intrusion and mold. Don't delay your investigations. Don't put it off. It's like deferring maintenance. It's going to come back and bite you at some point. You do have a duty to investigate and repair. It's extremely important. And I think that that is the big takeaway from this case. So read it if you want to feel terror at Halloween, if you like. But again, just take what your experts tell you seriously and don't ignore the fact that you might have a problem in the common area that needs to be fixed. And that's all I wanted to say about that. We're at the end of our time, and I wanted to give you guys a couple minutes for questions. So I hope that that's possible.
That is possible. We'll go ahead and start off. So they kind of came in as you guys were going through the bills. So I'm just kind of pulling some from each of the bills you guys talked about. So for SB 625, what is the definition of governing documents?
Well, I think that that would be the same definition found in the Davis-Stirling Act. So you're talking about CC&Rs, bylaws, rules and regulations, articles of incorporation, those types of things. Yeah.
Yeah, all of that is considered to be governing documents. And
right.
Yeah, I think that if you just look to the Davis-Stirling definition of that, then that will answer that question.
Yeah.
Which can be found on our website, guys.
Also
regarding SB 625, who is the body, HOA or the city?
The HOA.
All right, so our next one has to do with AB 130. Our association's attorney has interpreted the new AB 130 to fine $100 a day, as each day represents a violation. Is this legal? Therefore, the fines keep accumulating every 24 hours.
There's a split of opinion on that. And so I don't want to say yes or I don't want to say no. We really don't know if that's legal. I don't know how you're leaning, Jamie, but I don't think you're allowed to unless you can define violation. And if it's a continuing sort of nuisance type violation, perhaps you can. Or perhaps not. This is what I mean by it's going to need to be litigated because there are differing interpretations of that.
Yeah, I think that that's one of those really sticky situations we're facing right now, and we have no guidance from the court system yet. So I think the answer is stay tuned and know that attorneys don't agree on that one.
It may be perfectly legitimate for that attorney to advise you that way.
Yeah.
And we're going to test it. And we're going to find out what a judge thinks, and we're going to find out how that plays out in court. That's the only way we can resolve this because there are so many different interpretations and opinions out there on that.
Yep.
I think a caveat to all of this too is for all of our viewers, as much as we try and help, if we can't answer your questions, you guys need to seek legal counsel. So a lot of times they have to look at your documents and your specific situation to be able to give you what applies to your association, right, Jamie and Rob?
Yes.
And that person did that too. They're wondering if their attorney has advised them properly. Well, you can rely on that.
Yes.
They are professionals and they have a reason for advising you that way. And so I'm not going to question that here. I'm just going to say that there are different opinions about whether that's viable or not.
What do you mean? Attorneys have different opinions?
Yeah. Yeah.
Believe it or not.
It's very case specific.
Yeah, you guys should see us when we have our partner meetings. We argue about everything. Great.
Right, we're past the hour. Thank you to everyone who has stuck around. Please make sure to stick on and again, answer the survey if you would like your CAM ICB credits. Thank you again to all of our attendees and most importantly, our speakers, Jamie and Rob. As always, please do not hesitate to reach out to us with your questions and we'll see you guys next time.
Thanks, everybody.
Thank you.
Thank you for joining us.
Bye.